Hey, it's good to be here with you, and I'm so glad you're getting started early and learning about this new leasing, this new shell development. It's better to do it now ahead of time than after the fact. And that's the best way to learn, by coming to these educational meetings, talking to one another. That's how you'll get ready for it. And that's how we got ready for it. We're a little bit ahead of you. You know, we've got quite a few permits in. We've got some wells in. So you can learn from us, as we've learned from the Bakken Formation in North Dakota, the Eagle Ford Formation in Texas, the Marcellus Formation in Pennsylvania. All those have been places that we have looked as well to see what would happen, to see what landowners and farmers were dealing with. And I encourage you to do that and go to all the type of meetings you can. Before we get started here, I think my PowerPoint will pop up in a couple seconds. I think what will be helpful to you is to understand how leasing starts and takes place. And I can put that in perspective for you by telling you my own personal situation and that of our counties. I work in Guernsey and Noble counties, southeastern Ohio, and that area is pretty hot activity as far as leasing goes right now. But it wasn't always. I've heard some of you ask questions about, well, when is this going to happen? How fast does it change? Those kinds of questions. Well, as little as a year and a half ago, we had an offer on our farm at home for, I guess start off at $50 an acre. A little bit later, probably within a few months, went up to $250 an acre. And I'm talking about one company trying to lease the farms, same company. The terms we were offered in those leases weren't much. Very few addendums or changes to the lease. We couldn't ask to change much. And Saturday, the same company came to the kitchen table. They had completely written in all the addendums I wanted, made the changes I wanted. Remember, a year and a half, $50 an acre. A little bit later, $250. They're back at the table Saturday for $5,250. They went from a 1/8 royalty, which is our state minimum, to 20% gross royalty, no deductions. And I tell you that to tell you how things could change. What changed in Ohio to make those things change? Well, first of all, we got proof of production. You know, it didn't do. We had state geologists with companies had geologists. It's all good to talk about, but until the oil flows out of the ground, you don't get those kind of terms. So once that proof came, then we actually got those kinds of terms. In the process, a lot of people signed. A lot of people signed early. Didn't get good terms, didn't get good royalty. Some angry people over that. Others were patient, and many got pretty good terms, pretty good leases and royalty later on. And so leasing changed. At first, we had landmen, primarily, not very many drilling companies coming to our area trying to lease the ground. It was primarily people looking at acquiring leases on farmland with the purpose of selling them to another company later. And in flipping the lease, they make some money. So we saw those sort of folks early, the intention to turn over those leases. Later, now, we're dealing with major worldwide companies who are drillers and developers on those leases. So it has changed. Tactic has changed, therefore. So at first, put yourself in the position of a landman. You make your living getting leases, maybe flipping the leases. You don't necessarily represent any particular company. So you, as a property owner, think about what you're hearing in conversation and ask yourself, the person I'm talking to, are they employee, are they administrator for a particular company? Can they make oral presentations to me, not in writing, and will they stick? I would tell you in leasing, if it's not in writing, it's not agreed to, regardless of who says it. The other thing, there's a tactic. Those early comers in trying to get leases, if I ask you to go out, and I threw this out in one of our presentations, we had a group of Amishmen there, and they talk about raising a lot of fruit. And I said, if your job, some of the Amish boys there in the audience, was to go out and pick fruit, and your dad said to bring in a bushel, what would you do? Well, they'd run to those apple trees, and they'd pick them. Whatever was low, easy to grab, and move on. Be done quick. That's kind of how leasing went in our area. Fast, hit you quick. If you fought them, wanted too much terms, we'll move on. What did it do to you folks? Well, it made you nervous. It made you feel like you're going to get left behind. In fact, I might even tell you that if I'm a landman. You know, we're going to be here for a short period of time. We're looking for 10,000 acres. We're gone. You'll get a little itchy. Maybe your neighbor signs. You don't. You think, well, I could lose out. Company's got all this ground around me. You can see the process that takes place. Well, I guess we'll get that PowerPoint up in a second, or maybe all I have to do is hit the button. Okay. So I want you to understand that, because during the process of leasing that's going to take place for you in the next couple years, you're going to be under a lot of stress. Yeah, a lot of stress and negotiation. And if you try to do it yourself, wow, it's almost going to be your full-time job if you really want to get good terms, because you're back and forth to the table discussions. And you're going to have to think about the terms in the lease that you will stand for and mean something to you, and you will not give on. The company will do the same, and things you will give on, because that's what a lease is. It's good for you, and it's good for the company. And somewhere in between, you meet on the deal. Realize what you're given. It's just like if I'm trying to buy your combine. When I come in there, I'm going to want a new set of tires on that combine, new set of belts, maybe a new set of chains. I'm going to ask for whatever you'll give me. Well, leasing's no different. It's just like that. All right. Well, this is Chris's presentation here. All right, should flow right into it, huh? Well, going the wrong way. Big buck. All right. Here we go. All right, I'm going to cover some of, I can't really get into all the details on leasing, all the minute things, but I hope for you today, I'm going to cover some big things that you will think about. It should weigh on your mind. And for you, weigh these items, whether they're negotiable or not. Go to your attorney and make sure they put the things into place for you that protect those items that are important to you. I'll talk some about pooling. I think it's important to all landowners. I'm going to cover landowner groups, because I told you initially how the leasing went prior to this time. But lately we've had these landowner groups form in Ohio, and they're interesting creatures. I'll tell you about those. And be sure and consult an attorney really before you sign anything related to oil and gas production. Simple question I have here for you at the top of the page. And we saw people that get stuck on this. What is this lease for? I guess maybe you assume I come to you and I say I want to lease you for oil and gas. If you read the fine print on a lot of these leases, they'll say for oil, gas, related hydrocarbons, water, other constituents. Define for me other constituents of the earth that may be of value 50 years from now. Do you really want to include items like that on an oil and gas lease to an oil and gas drilling company? Think about what is being leased and what it's for. Don't make assumptions. about the acreage that'll be included on the lease. List out the acres, number of acres, the amount of payment. We had some people get surprised. They go to sign the paperwork, and people trying to get the lease didn't want the entire farm. They wrote in a different amount of acreage. So do not make assumptions on anything, and if it's not in writing, it's not been said. Consideration or signing payments, those are those signing bonuses Chris talked to you about. We've seen them worked in a couple different ways. One is we've seen farmers take these over a period of years. They might want to save some taxes, spread that out over 5 years, 2 years, depends. We've seen a few companies go bankrupt and payments stop. Think that'll happen again? Guarantee you. What happens? They've got a lease, they're not getting payment anymore. Back to the drawing board. Yeah, get that cleared up. And then lately, we've seen payments being one-time signing bonuses you get at the time you sign the lease. The problem is we'll use bank drafts or money orders to make payment. And if you've not been familiar with bank drafts, they're common in the industry. And what happens is we get a period of business days to pay on that lease. In our case, it's been 90 to 120 business days. Most of the major companies that came to our area have not been able to meet that. And the reason is our recorder's offices are swamped. There is no parking spot around the recorder's offices. It could take you hours to make copies just to get access to make copies in the recorder's office. There is no counter space to flip books. They had to limit it to 20 people in the room. Our records are not computerized. I know some of yours won't be either. It was hard on those lease record books. Pages were getting torn and so on. Our office hours were increased sometimes till midnight. And to give you an example how busy it was, in Guernsey County last year, in 2011, during this first quarter, we made $140,000 on copies. Sounds like a big quarter, I thought. This same quarter this year, over $400,000 worth of copies in 2012. That's how busy the recorder's office is as abstract researchers and companies look at your lease records going back 100 years. So, can you lease? Do you really know? Did you research your land records going back 100 years? You think anybody has ever gotten a payment and been asked to pay it back? We have a couple farmers who got in that situation. They found out they actually weren't leasable. They received a large signing bonus, and it's gone. And now they're fighting with the company on what to do about that. I think all farmers want to be honorable, and I think you should. That's why I work for you. I believe you are. And you owe it to those who you might be considering selling your mineral rights to do some research. I'd encourage you to do it now before those recorders' offices are packed, and they will be. It could take you hours to do that research work, and it could take you days a year from now, and it won't be as an enjoyable experience as it will be now. So represent your property to the best of your knowledge and do that research, whether it's you, your attorney's office, or a title abstract researcher. But try to say to the best of your knowledge whether you own these minerals or not. Don't throw it out there and say, well, I don't know, I think I do. Oh, I didn't really know that. Because you cost everybody who owns their minerals. You cost them time. It takes hundreds of dollars. Big case went through in Guernsey County here this fall. Signed thousands, tens of thousands of acres. About a $300 million deal potentially. 55% of those landowners were kicked out. So far, the 120-day bank draft period has elapsed. 55% had title problems. All right? They weren't leasable so far. That is a lot. Old wells, not release of leases on the property, just issues that needed resolved. That's one case. You know, I hope we don't end up that high of unleasable property. But in that particular case, that's where the stats are at this time. So do your homework now. Right now, those farmers that got kicked out of that deal, the peak might be by them. The offers might be by them. They might have to wait longer. They might get left out of leasing, all because they didn't do their homework and find out whether they were leasable. They didn't work with their attorney to get their property cleared up. Don't let that happen to you. Stepping back to square one now may cost you a lot of money. Bank drafts are a tricky tool. I'm not comfortable with them. I would rather you exchange your signed, notarized lease for a company check, certified check. But a bank draft is a conditional form of payment. And on my bank draft, we like to stick in a little phrase there that neither party shall be obligated for payment. Ooh. Makes you wonder during the next 120 days whether you're going to get paid or not. All right. And if I was buying your farm, you wouldn't consider that farm sold until you got the money. You'd continue to talk to folks about buying your farm. I think you should maybe try to look at your mineral rights like that as well. Perhaps you can hold that lease in escrow at your attorney's office and exchange it for money if you are leasable down the road. You realize a lease has a primary term of a lease. You need to look at your lease as having segments, terms. A primary term is the time from when you sign that lease to when drilling takes place. In our case, it's been generally, most farmers would have got about 5 years on the primary term. You look in different areas like Texas, they'll stick that to 3 years. And the idea is we try to get developers of oil and gas to develop it or release it, because you get the money through production and royalty, a large part of it. Look at that, because there's ways to extend a primary term with a minimal payment automatically. What happens at the end of the primary term, the end of 5 years if no well is drilled? Deal with that extension. And that should be either, in some cases, we were able to get, again, our signing bonus at the end of 5 years. So we get it again. If you want it, you didn't drill, pay us again. Some cases they got 110, 120%. Should be worth more if the resource is good in that 5 years. In other cases, landowners forgot to do anything with that. So it was an automatic extension. So look at your lease as having those components. And of course, once you get a well, then you're into the production phase of your lease and your royalty kicks in. Make sure any payments you get, like your consideration signing bonus, aren't in lieu of first years of royalty. You always want to check that. A pew clause, some people forgot that. I think for you guys with large landowners, this part of the country, pew clause would be good. It deals with your ground and releasing ground that's not going to be produced. Look at having that in your lease. We'll talk more about that in a little bit as it relates to unitization. In Ohio, we didn't have a unitization law. What that means is companies came in and they wanted to try to tie thousands of acres under a unitized lease. Companies like to unitize because it gives them the right in unitization and pooling to best develop the resource, because they can drill anywhere on those combined contiguous properties. For you as a property owner, it generally means that you're going to be sharing royalty with those property owners in there. The other thing that it could mean is that you could be tied by production a mile away or more, having never been developed. Perhaps even an injection well would hold your lease 2 miles away. Maybe even a storage unit 2 miles away. So held by production is a very important part of a lease. And you can deal with that in the pew clause and unitization. We've been successful at reducing leases to 640 to 1,280 acres, a maximum to be unitized for this horizontal drilling in Ohio. I was talking to your Farm Bureau attorney back there earlier, and They'd like to reduce that even more. I don't know where it'll shake out for you all. But it's an important notion. Try to keep that acreage as low as possible. And if it's not mentioned in your lease, make sure you do put it in. We've also seen lately, and realize I'm talking about these things because at first we didn't get them. Now we are. Top leasing. You familiar with that? We have some people so interested in your lease that they say, and we'll sign an agreement with you, that at the end of your 5 years, we want to lease you. Sign a top lease with us so that we have an opportunity to lease your farm before it's even up for lease. And that we must match the terms that you've been offered. And the company that currently has you, maybe you give them the first right of refusal on your lease. Think about including a top lease provision or maybe a most favored nation provision. And that if better terms or better money are offered by the same company within your area over a given period of time, they have to match that offer to you. Think about that. And at first, we didn't get these kind of provisions. And at first, farmers forgot to ask for something as simple as a spud fee. Your ground is so productive. It makes Chris and I envious when we drive over. The crops look so good here. It's such a breadbasket of America. You're going to lose some production if a well takes place on your property, and more than that. A spud fee. At first, farmers forgot to ask for anything. Now we're getting $30,000 per well site, $25,000 to $30,000 if you'll ask, because a huge amount of acreage we lose, perhaps forever. The other thing is that we lose production on part of that ground, where the roads go in and around those areas. Spud fees can be important, and they're given to the property owner where the well is drilled as compensation for property loss, if you will so ask. The other thing is our treasurer's office is very excited about drilling. Why? Because if you get that well pad, they're going to tax you at commercial rate on your property rather than agriculture value. Yeah, they're excited coming to these meetings. The other thing they're asking is that, oh, you're going to have to pay recoupment on your CAUV tax as well, based on that acreage that well goes. So you'll feel you want that spud fee. Shut in. Chris, I thought, threw up an interesting figure to you on 2%, and when we went to Pennsylvania, 2% at that time last year, the property owners were receiving royalty. What did that say to you? Something must have ran through your mind. Did it say to you that only 2% of the farms, 2 out of every 100, were drilled on? Did it say to you that? Did it say to you that maybe they couldn't get the infrastructure put in? Well, what it should say is that he didn't tell you that only 2 out of every 100 leases were drilled. He didn't say that. What it most likely means that the infrastructure isn't there. We drilled on a unit. We shut it in. A shut-in well is a well capable of production. And when that well's capable of production, it holds your lease. Just a well capable of production. And we move on to another unit and drill another well. So if you ask for, perhaps you can get a shut-in royalty or payment, sometimes referred to as delayed rental. But you need some kind of compensation because your well, if you've ever been a well owner like me, wells are shut in periodically, sometimes for maintenance, sometimes for low price, sometimes because we need to get on and tie up some more leases. You need some compensation for that. And ask yourself, when does it kick in? If a well's shut in for 180 days, 90 days, is that per calendar year? Are those consecutive days? Are those cumulative days per calendar year? When is that payment due you? Name that in your shut-in royalty or delayed rental payment. Royalty. This is what everybody likes to talk about in our coffee shops. what the royalty they're getting and by itself it should mean very little to you. Our royalty started off at about 1/8. Today, we're at 20% royalty. So that gives you over a year and a half period how we've changed. Maybe you'll change that way. But if I don't talk about royalty in whether it's gross, whether it's net, whether there are deductions that come out of your royalty for production, separating, condensing, transportation, what comes out of royalty? At first, we weren't able to negotiate anything out of royalty. We got our state minimum in most cases of only 1/8%, and that works out to 12.5%. And today we're getting near 20% gross and no deductions capable of being taken out. So it changes based on proof. Very important area of your lease. And then royalty is also based on a quantity as well, right? And ask yourself where that quantity was established. Was it established out of that hole? You paid based on what comes out of that hole? Or you pay based on the point of sale, where maybe it sells in Houston, Texas. Maybe you're paid based on the first marketable point of your products. But a quantity is established at some point in that production line, and that can make a difference. And the other thing is the company selling to a sister company, a subsidiary, a company they own? So how's price established? Is it locally published prices for those commodities? Is it the price received? And then also related to royalty and production is what happens to product that's used to run that generator bank that Chris showed you earlier. Product used. Did you ask for it? Did you address it in your lease? Something that we see left out of many times in leasing are a description on what happens if you default on the terms and payment. I have many leases I've copied out of the recorder's office that say this: this lease cannot be canceled for reason of non-payment, breach of terms, or covenants. I think if I was buying a combine here and I was looking at some prices, $200 and some thousand, I'm going to take that to that John Deere dealership and say, hey, I'll just take a loan out, but I'll sign the agreement. You sign this. You don't have to. Will you sign that? What happens in the case of non-payment? This lease cannot be canceled for reasons of non-payment, breach of terms, covenants, and conditions. People went through the trouble negotiating leases and signed statements like that written right into their leases. Absurd, isn't it? And it's sick. But it happened a lot. Did you cover that in your lease? Read all those pages? Our leases went from 4 pages to over 20 pages now. Fine print. What does your lease say about that? Sometimes I guess we got too excited about the money we were going to get, the royalty we're going to get. Man, if I was renting your house, you'd have clearly stated what happened if I didn't pay. You'd have a procedure, a notification, written notice. You'd have a statements that state what happens with my merchandise. You need to have these kind of statements in oil and gas leases as well, because it'll happen to somebody in here. All right. Cases of bankruptcy. Companies disappear. Can you take collateral of that product and market it on your own? Yeah, we've been able to get that in our leases lately. Companies will go bankrupt. How about changes in your CAUV status? I told you that happened in our area. That's going to change where those wells are located. We've been able to get lately, not early, that if our taxes, property taxes change and we notify the company, they'll pay for those changes in our property tax. They'll cover the difference if we notify them. Originally, people didn't put that in there. And the same can be true for other government programs. I notice you have a lot of CRP ground here, other government program grounds. you need statements that protect your government ag programs, because you may be asked by the federal government to pay recoupment on those kinds of things.